is right in this case.
But he can't, but Mr. Mohammed, hold on, I'm sorry to interrupt, but he can't assert his right to a speedy trial until he knows he's been charged, and the charges didn't come for 2 years after the arrest. Yeah, you guys don't have to jump up to talk to me. All right, so I read the pleadings. I'd like to just touch high points and maybe give you a chance to do some more argument.
Judge, this is, I think, a classic case and why there's a speedy trial requirement. This case just went south because he was arrested in May of 2015. The blood test came back in June of 2015, so the case was ready. There was no reason why the case wasn't ready to go, but he wasn't charged until November of 2017. So obviously we have a long time. We don't have a reason for the delay. I mean, I guess the reason would be that they were busy, and I don't know any other reason. And since that time, my client moved out. I mean, he didn't know that there was anything going on, and he moved to Florida. So he didn't have any contact with the court. He went through a divorce. He had contact with police through a couple traffic tickets, but nobody ever told him. Finally, in 2025, he was told, hey, there's something in Michigan. And he, at that time, came and he took care of it. When he did take care of it and was arraigned, he had his court-appointed lawyer demand his speedy trial. That was the first time he was in court, first time he had a chance to do it. But more importantly, when you look at the case, I mean, there's a lot going on here. The police have lost the records. Prosecutors said they have enough to proceed, but the police don't have anything. They have nothing. We're going to have a lab tech from back in 2015. One of the officers that was Officer Audrey, she's, from what I'm told, is gone. He's going to be hard to locate. And that's saying they can't, or they can't, but he's going to be hard. My client at the time of the incident was with a couple people that are gone. He doesn't have contact with them. His truck at that time was a work truck. He had video on it. He could have had video, but he didn't think he needed it since it took so long, so he sold his truck. So there's all kinds of things. I mean, to me, this is a classic case of why we have a requirement to move forward, and why we don't move forward on these cases in Wayne County. I don't know. I don't see this in other counties. I'm not an expert.
Right.
Where it's happening, but I don't see it in other counties. So, that's my high points.
Okay, fair enough. Mr. Mohammed.
Because the delay, so just for the record, this case is from 2015 and charges in this case were authorized in 2017. Now, the delay that is governed by Michigan law is that once it goes past 18 months, the burden shifts to the prosecution go. And so while in this specific case, the authorized warrant for 6 months after the fact, that shift, all that is a shift in moving burden to the people, and it essentially triggers a analysis under the factors. So there was no violation by this warrant being authorized exactly 6 months after the 18 months. However, it would trigger an analysis under the factors. Now, that being said, the defendant failed to appear for his arraignment at that time in 2017. He was in the wind for over 8 years.
Hold on, stop. When was there an arraignment scheduled?
So
I'm trying to find it from the original register of action.
yeah, so under People's Exhibit number.
Okay, arraignment pretrial scheduled November of 2017.
Yes.
Yep.
Well, I have.
Yep.
Exhibit number 2, it is highlighted that there will be notice to appear for defendant requested on November 15, 2017.
Let me find your exhibit.
On November 15, 2017 at 9 a.m., there was a notice to appear for defendant requested.
Right.
On 11/15/2017, it indicates defendant failed to appear for the hearing.
When did he move to Florida? Do we know that?
No evidence presented to the prosecution that would show that he did move to Florida at that time.
Well, let's find out. Mr. Gagosian, when did you move to Florida?
So we started moving at the end of 2016, and we had transitioned everything over by February of 2017. All of our household products and everything have moved to Davenport by then.
Okay, go ahead, counsel.
So yeah, there was no evidence presented by the defendant or the defense to demonstrate that there was a move at that time.
Well, you just heard the evidence. That's evidence. That's testimony. That's evidence.
But yes, it's the people's position that the defendant has a ongoing duty to update the courts when they move. The defendant had.
Hold on. How could he have an ongoing duty to update the court when he didn't even know the court had a case?
Well, Judge, he was arrested. The arrest, I believe, serves as a potential notice to the defendant that charges are coming. So he was provided notice in that aspect. The defendant had 3 prior DUI.
Objection, that's not true. And we've talked about that. You keep saying that, that's not true.
Please let me finish my statement before you object. So the discovery packet indicates that the defendant had 3 prior DUI incidents. I believe it stems out of California. So he's familiar with the criminal process. He's familiar that the court would govern a court hearing and charges, and that we believe that that interaction between the defendant, the police, and even Your Honor, I believe Your Honor signed the search warrant that led to the blood draw for this specific defendant.
Which he never saw.
Correct, but he went through the process. I'm sure he was arrested, Judge, and he was transported, and I'm sure.
Okay, but that doesn't create the obligation for a defendant to notify the court because there may be charges brought. So move on with your argument.
So, okay, and I understand, but we believe that it is that being arrested, it does create a responsibility to at least check and be updated and be informed. We learned 8.5 years later almost.
The courtroom grows increasingly tense as the defense argues that the defendant's constitutional right to a speedy trial was seriously violated after years of delay and inactivity in the case. Defense attorneys stress that although the arrest occurred in 2015, formal charges were not authorized until late 2017, by which time the defendant had already relocated to Florida and was unaware that any case was still pending against him. They argue that a person cannot be expected to assert their right to a speedy trial if they have no knowledge that charges even exist, describing the delay as both unreasonable and deeply unfair. Prosecutors, however, argue that the defendant still carried some responsibility to remain informed following his arrest and claim that his move out of state contributed to the complications surrounding the case. But as the hearing continues, Judge Oakley openly questions the prosecution's handling of the situation, expressing visible frustration with the Wayne County Prosecutor's Office and the repeated delays in DUI-related prosecutions. The judge ultimately focuses on the issue of fairness and constitutional rights, concluding that the defendant was denied a proper opportunity to defend himself in a timely manner. In a dramatic ending, Judge Oakley grants the motion to dismiss, delivering a strong message about accountability and the importance of protecting due process within the justice system.
He found out about this case. I mean, it would be his position that it would be speculation. We could speculate that he disappeared for 8 years for officers not appear, for us to have trouble with our case, but we're not going to do that. So we will just base our position based off of the facts, and the facts in this case, specifically the register of action, indicates that notice of appear was sent to the last known address, so we have to presume that notice was provided. I understand it's his position that he moved prior to that date. However, I believe we need more than just his, testimony, which isn't under oath this time. And we would just need a little bit more to presume that he did not receive notice. Because at this point in time,
Well, be careful though, because before you walk yourself into a corner, because are you saying that if the defense can document that his residence had been permanently established in Florida before November of 2017, you're going to withdraw your objections?
It's not going to withdraw my objections. I think it's going to go to one, his credibility, and another additional factor the court can consider in making its determination. I'm not saying that's the standalone thing, but I think I understand the court's position, and I think that if I was a judge, I would definitely take that into consideration. And so that's our position. And
Okay,
as it relates to the remaining factors, we would just rely on the motion, which was pretty detailed, I think. Thank you.
okay. Any response?
Concentrating on the date of arrest until about over 2 years. That I'm not concentrating on. There were no charges. So I guess my counter argument to the prosecutor would be, when somebody gets arrested, how long does the duty, according to the prosecutor, how long does that duty last? Keep contacting the court and contact police? I mean, is there an end date on that, or does that last forever and ever and ever? I
Right.
mean, that doesn't make any sense. And there's no question that there was no charge for over 2 years. And that's the key to, that's the crux of
Right.
the argument.
Right.
And just to be clear, my client had a drunk driving out of California 20 years ago once. So something within that discovery packet that said something else, but that's what it is. So my argument is contained to the date of arrest, to the date of charge.
Okay.
Thank you.
Yeah, go ahead.
In regards to the 6-month delay, which is really what it is, and I believe,
Hold on. Where are you getting 6 months?
so it's a total of 24 months from the date of the arrest to the defendant being issued.
The issuance of the warrant. Right.
And so after 18 months, that's what could trigger a speedy trial analysis. So the 8 months is, or the 6 months goes from 18 to 24. So there's a 6-month gap. So that's really the delay. The 8.5 years is not anything that the prosecution did. It's the defendant moving to another state. So that has nothing to do with us. The warrant was authorized within that time frame of 24 months. And so, Judge, when we're reviewing this type of a motion made by the defense, we have to look at the 4 factors. And one of the most important factors is whether or not the defendant asserted their right to a speedy trial. And in this specific case, when we're reviewing the facts, there is a failure for the defendant to assert his right in this case.
But he can't, but Mr. Mohammed, hold on. I'm sorry to interrupt, but he can't assert his right to a speedy trial until he knows he's been charged. And the charges didn't come for 2 years after the arrest.
So Judge, you can.
How do I exercise my right to a speedy trial if I don't know I'm going to be tried?
Well, Judge, they can send certified letters. We get our office receives certified letters from individuals, and they could have.
It said you arrested me a year and a half ago, and are you coming after me? That's what the letter says?
Once it was past 18 months, yes, and I was at the.
Okay. Well, here's what I'm going to do. I'm a firm believer that bad behavior has to hurt or bad behavior continues. And I agree with Mr. Duncan. This is not an unusual problem out of the Wayne County Prosecutor's Office, especially on drunk driving cases. This case is dismissed. Feel free to appeal me. Ready?
Yes.
Come on up on Jones. Oh, this is part of that file.
In the closing moments of the hearing, Judge Oakley delivers a decisive and strongly worded ruling that brings the long-running case to an abrupt end. After reviewing the timeline and hearing arguments from both sides, he emphasizes that the core issue is not just delay, but fundamental fairness under the Constitution. The judge points out that the defendant cannot be expected to assert a right to a speedy trial when he was not even aware that formal charges had been authorized for years after his initial arrest. He highlights how the case lingered without proper follow-up, especially after the defendant moved out of state, and questions how such a breakdown in communication and procedure was allowed to continue for so long. Visibly frustrated with the prosecution's handling of DUI-related cases, Judge Oakley directs criticism toward the Wayne County Prosecutor's Office, suggesting that repeated delays undermine public trust in the justice system. He rejects the argument that the defendant's relocation alone justifies the prolonged inactivity, making it clear that the responsibility to move a case forward lies with the state once charges are initiated. As the courtroom remains silent, the judge concludes that the defendant's constitutional right to a speedy trial was effectively compromised by the lack of timely action and proper notification. With a firm statement, Judge Oakley grants the motion to dismiss, immediately ending the proceedings. The ruling not only frees the defendant from the pending charges but also serves as a striking reminder of the importance of due process, timely prosecution, and accountability within the justice system.